Mm,
Okay, let's move to Sylvia B. in Brownstown or Brownstown.
mhm.
And Sylvia says, my friend and I signed a contract to buy a piece of commercial real estate. I was the only person who qualified for the mortgage. So my friend still came up with the money for the building, but they are no longer on any of the mortgage papers or on the deed. He now wants to be put on the deed or wants to get his money back, $48,000 and 50% of the property value returned to him. What can I do here and what am I obligated to do here? From Sylvia B. in Brownstown.
Okay, so first of all, it never fails to amaze me, although I'm very pleased at the same time. It's like the most unusual dichotomy or emotions. You know, they didn't have it sounds like they didn't have an attorney going into this commercial real estate endeavor, okay? And so now they need one.
Mm,
And, you know, a lot of the heartache that they're about to experience, because it's going to be expensive, uh, could have been avoided by just going to an attorney initially and getting this figured out, okay, up front. So the first thing is it's very common that sometimes the banks will, especially in commercial deals, will say, you know what, we do not want so and so to be on the property because their credit's no good, but we'll let you, the partner, be on the property. That doesn't take away from what we call the legal contribution that the other party makes. Okay. So if these people had an arrangement, if the partner who's not on the mortgage now did give the 48,000, and you can see the machinations of how the deal has come through, even though there may not be anything in writing per se, or even though the bank says you got to come off the deed and you stay on the deed, that doesn't take away from the fact that they're most likely 50-50 partners in this deal. Okay, that's number one. So even though it's not in writing, it doesn't sound like there's anything in writing. Um, the partner who's been forced off the deed still has a right to contribution. They still have a right to their $48,000. Okay, that's what they contributed. And then, for lack of any other type of split, it's going to be assumed that they're 50-50 partners. Got that?
mhm.
And we would support that with any other corroborating information, such as emails, under, posting notes, whatever it is. You can do that because there's something called, even though things should always be in writing in real estate, there are certain exemptions or exceptions, pardon me. And the exception to this rule, it's called the statute of frauds. You've heard me talk to you about it before. I wish I could have a vanity plate on my car that says statute of frauds. I have, been blessed by helping correct this area for so many people when it comes to the real estate problems. But the statute of frauds requires everything to be in writing except if you have partial performance. So you
Okay.
can have an oral agreement between the parties. And how do you prove the agreement? Well, performance. This individual who's off the deed gave 48,000. Okay, so we know they're part of the deal. They didn't give it as a gift.
Sure.
We don't know, but I'm sure there'll be information that we find out that shows you maybe a loan application that they both made initially, right? It wasn't accepted, but it's still used to show what the party's intent was. Okay,
Mhm.
because they filed a loan. There's so many different things that we can look at to help support the party who says, I'm owed 48,000 and I want 50% of the equity. If this was all in writing, we would call this a partition action, which is a whole other legal theory, and it's basically the division of real estate by the court when parties can't agree on something on their own.
Mhm.
All right, they call that a partition action. So this person who wants to know about what do they do? Well, if you really know what the agreement is, it's cheaper to honor the agreement. Okay.
Yes.
Be honorable, honor the agreement. If you can't, then come see an attorney like myself in real estate. And, there's other ways to go about trying to resolve this matter, but nobody really wins when they litigate. There's always, it's expensive. If you
Mhm.
let a third party make the decision for you, which is usually a judge or an arbitrator, you'll be very disappointed. So it's better for the parties to come to a resolution or try to work on a resolution together instead of going to court. And attorneys, there are a lot of attorneys like myself who will still work to mediate something and try and get that resolution. Nothing makes me happier than not going to court. And believe it or not, I'd rather not go to court.
Mhm.
There's some fine judges out there. That's not the issue. The issue is people are never happy going to court. So if we can try and mediate it and get it resolved between the attorneys and the parties, it's actually better for all parties.
Well, in her question, she says that her partner wants either to get this money and 50% of the value or to be put on the deed. Now,
Oh, well, here, I didn't catch that part. I was
Okay.
so into the other part, but let me quickly tell you, now that you mentioned that, I actually, maybe I did hear it and I just didn't address it. You want to be on the deed, that's fine, give them the deed, except here's the problem. That deed can't be recorded without the bank's permission.
okay.
The bank made a loan to that one
Mhm.
individual for a reason. They
Individual.
don't want somebody else. They don't want any deed to be conveyed out. You've heard due on sale.
Yes.
There's other legal provisions besides due on sale. In this situation, the lending institution, being a commercial lender, most likely will be like, you breached our agreement. Simple as that. It's not due on sale. We gave you the loan. We want you on the property. That's it. So that second part has its own,
So putting
section.
them on the deed is not that simple.
That's not the route. I mean, you could probably reach out to the lending institution and the loan officer and ask them, hey, can we put so and so back on the deed? The likelihood that happens is going to be very remote. I personally don't feel it affects the property once the lending institution has the first lien on the mortgage and can, they know who they made the loan to and their first priority lien holder. Who cares?
Sure.
But there are banks and investors who do care, and they don't want anything to mess up the title, and that could mess up the title.
Okay. Okay. Well,
Boy, that was pretty intense.
this sounds complicated.
Yeah.
Pursue with an attorney.
Proceed with caution. Right?
That too.